Good afternoon, all the participants for joining for this particular additional session. We are thankful to Dr. Ravi Adhwaryu for this special session. I requested him day before yesterday and I immediately agreed, sir. I'll be happy to take the session on the Land Grabbing Act that's again prevailing in 3, 4 states. Recently, I think in Odisha also. It's a very particular topics and very crucial nowadays, and we have seen many cases on related to land grabbing across the country. Again, unfortunately, many states have not implemented this particular law. So today we have Dr. Ravi Adhwaryu. He's a legal superintendent in Department of Forest and Environment in Government of Gujarat, and selected by Gujarat Public Service Commission. So before that, he was a faculty at GLS Law College, Gujarat Law Society Law College at Ahmedabad, and before that, he was in Anand Law College. So he's very keen researcher and then very active academician, young scholar, I would say. And then definitely, he will throw some light and insight on land grabbing act in India. So, as I already communicated to all of you, he did PhD on this particular topic. That's why immediately I requested him to throw some light and share his experience and his research work done in the PhD work. So, on behalf of organizing committee, we welcome you, Dr. Ravi, and I request you to enlighten our participant joined from all over the India. Over to you.
Thank you very much, sir, for your kind words. With your permission, may I start, sir?
Yes, 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 please.
Thank you very much. Good evening to all of you present over here. Myself, Dr. Ravi R. Adhwaryu. First of all, it is my honor to present and to conduct a session on my PhD topic, which is actually a very burning issue in India nowadays. Though it was there, a burning issue since long, but it is now came to the notice to the government as well as to the people that this issue of land grabbing should be actually be taken away into consideration within the purview of law. When we say law, it means that there should be some kind of legislation in order to curb this malice of land grabbing. If you could see the slide, this is very important part. First of all, there are two methods of acquiring the land. Land is the surface of the earth. You can acquire legally. It may be from an individual. It is called acquisition. Acquisition by transfer of ownership, by sale, gift, etc. The specific wording here is ownership, not possession. In jurisprudence, this concept is very well in detail elaborated. There should be ownership over the property, particularly when we refer here is the land. There should be ownership, there should be the name of the specific individual in the title records. Revenue records, popularly we call it as a 7/12. So there should be some kind of transfer of the ownership from individual or from the government or whatever it may be, but there should be the name in the title. It may be by consideration, sale, gift, or by any other medium. So in India, there are various laws under which this kind of legal transfer of the ownership is permissible. It is generally under the Transfer of Property Act. It may be under the succession laws, ancestral property from so-and-so person to the legal heirs. It is permissible. Government is also entitled. It has the right to acquire the land for the public purpose as per the doctrine of eminent domain. But the procedure as per the 2013 Act of the Land, right to the fair compensation, resettlement, etc. Under that, there is one procedure which should be followed by the competent authority. It may be in Gujarat or in India, we have also National Highways Act, Gujarat Highways Act, under which the government, it may be a specific body which has been authorized to take that property, that land. So here the main purpose is that whenever due procedure is followed, then that kind of acquisition is considered to be the legal one. On the other hand, land grabbing is an illegal method. It is a wrong. It is under the civil laws as well as under the criminal laws that any person, if without the permission of the other, who is actually the owner, is taking away, is snatching, is illegally getting the land of the another person, then it is called land grabbing. So this is the first point, that land grabbing has nowhere connection with the land acquisition. Here somebody has taken away, has snatched away that land. So at that time in India, we have various BNS, acts of, for example, Civil Procedure Code, under the Specific Relief Act, the remedy is available. General laws. In general laws, the procedure is there, but there are so many general laws under which the remedy is available. As I mentioned earlier, that land grabbing since last few decades has been considered as a in fact burning issue. So government is taking keen interest to curb this malaise, and for that purpose special laws are being enacted. There are only few states who have enacted such laws, which we are going to deal by one to one. So here in this session, we are going to cover mainly 5 points. That what is actually land grabbing, its small historical development part, what are the essential elements, what is actually land grabbing in India as well as under the international law. In India, as I have mentioned, various states have enacted the concerned law to prohibit it. What are that laws? What are the rules? What are the judgments in it? In case if there is no such law has been enacted, then what are the allied laws? What is the provision under the Constitution of India, which is the highest law of the land? What is the provision under the international of land grabbing in 2015? So it would be followed by the discussion and the question answers. So let us start by the point of the constitutional law. So whenever any law, any specific legislation is enacted by the union as well as by the state, it is always being considered in light of Article 13 of the Constitution, that whether that union or the state has properly enacted, do it really authorize or entitled to enact that law? Particularly with regard to the land grabbing, as we all know, as per 7th schedule, read with Article 246 of the Constitution, there are 3 lists: union list, state list, and concurrent list. For the purpose of land grabbing, it is the part of list number 2. That is entry number 18 and 64. As per it, the state legislature is empowered to enact the law because it is the part of the subject matter of the state list. So generally in India, the state governments have enacted the specific law regarding the prohibition of the land grabbing. So the title of the law which the state have been enacted is called Land Grabbing Prohibition Act. For example, in Gujarat, it is called Gujarat Land Grabbing Prohibition Act. Earlier, I have mentioned these 2 kinds of the methods of acquiring the land. Here, there is specific mention of the right of the government to to acquire the land for the public purpose under the doctrine of the eminent domain. Here, when we talk about this right of the government, it is the part of the right to property. I think in this session, most of us are either law students, faculties, or the part of the legal fraternity. We all know about the 44th Constitutional Amendment 1978, in which earlier there was right to property, a fundamental right under Article 19(1)(f), read with Article 31. But as per this amendment, this right to property has been now transferred to the constitutional right only. It is the right, but not a fundamental right. The relevance about this thing is, as per the land grabbing, when we say about the right of the government to acquire the land in the public for the public purpose, there is one important judgment which I think everyone knows. It is the landmark judgment of the state of Himachal Pradesh versus Vidya Devi. In it, one of the core questions was regarding land grabbing, land acquisition, and adverse possession. Here, in this case, Vidya Devi was a widow of having the age of more than 80 years. She was a widow. She was having the land in Himapur area. That area of the land was around 4 acres. Without due procedure, without issuing the notice, without providing the compensation or resettlement or anything, government has straight away claiming to have the right over the land, which was actually belong to the government only. They have snatched away that land. In this case, the particular thing was that that lady and the relatives over the land were residing since more than 30 years. So at that time, she has filed the case before the High Court. It went all the way to the Supreme Court, and it was being held that government cannot deprive an individual having the right over the land, considering as a part of the adverse possession, when there is some conditions provided regarding the adverse possession doctrine, that when it is in the peaceful possession, exclusively, without any hindrance, without following the due process or anything which may deem fit as if the person is residing. So over and above, it was being held that a person, an individual, would get the right over the property, including the land, if certain period as per Article 65 of the Limitations Act arises. So this is the basic thing, that constitutional law permits the state to enact the legislation, though there is no such kind of restriction for the union not to enact that kind of legislation, because this is the part of the public domain. But generally, it is the part of the state legislature. So they have that duty to protect the land of their citizens. Now comes the part of the definition of land grabbing in India only. In India, it is wrong, it is crime. So both criminal as well as civil law will come into force in case if any land grabbing has been occurred. So this is one kind of general definition, which is actually the part of the 4 laws which are being enacted by the concerned states. If you could see the slide, you can refer to section 2E of the Gujarat Land Grabbing Prohibition Act, 2E of the Assam, 2E of the Andhra Pradesh, 2F of the Karnataka. So generally, the definition is common or almost common or identical in all these states. So land grabbing means every activity of the land grabber to occupy or attempt to occupy or so and so with force, threat, intimidation, deceit, any land which is generally belong to the government or any private individual, or to the authority, local authority, religious or charitable institution, and that kind of land grabbing should be by that person who has no ownership, title, or physical possession. So there should not be any lawful entitlement, but there should be some purpose of taking away this thing. So it may be like creating illegal tenancies, creating lease, license or agreement, or by constructing any unauthorized structure, thereby for sale, hire, or use or occupation for any structure. So this is a very broad kind of the definition which generally covers almost all the aspects of the land grabbing. So as I mentioned, there should not be, the first part is the ownership over that thing, over the land. So under that aspect, land grabbing should be considered. So generally there are four states who have enacted this legislation. That is Gujarat, Assam, Andhra Pradesh, and Karnataka. Each states have its own features regarding these provisions. So these are the essential elements that I don't think so we should go in detail, but it will cover most of the aspects. Now the need of land grabbing prohibition law. Land is a valuable property for everyone. It really takes a lot of efforts and money to have the land of our own. It is also the means of the basis, livelihood for many people. But there are some people who generally we considered land grabber or bhumafias who used to grab the land of the individual by fraud, misrepresentation, force, or any such other ways. So, when any kind of land grabbing happens, at that time, naturally, the victim, the person would become baseless, helpless. So, at that time, he would approach the police to the revenue authority to take back the land. So, at that time, there should be at least some kind of laws through which the procedure is established to take the action against such person, and if it really happens, then such kind of person should get behind the bars. So this is the need that over and above there should be some kind of legislations which empower the authorities to take action against the bhumafias. So as I mentioned, we cannot black and white say that this is the specific legislation, because from 1947, 1950 till 2025, we in India, we have various many numerous legislations in India. So land grabbing is generally not a common term. It is not a specific term under which every kind of category would fall. It may be encroachment, it may be impediment, it may be trespassing. So over and above, we have to refer the other laws under which similar provisions are being there. So it is like Panchayati Raj laws, municipality laws, criminal civil laws, anti-encroachment laws, anti-social elements, anti-unauthorized occupation laws, etc. So all these laws are in one way or another connected with the land grabbing. This was the first part that I have mentioned regarding in India. In India, this land grabbing is a wrong, is a crime, but this aspect of land grabbing is quite different at international level. As per the European Economic Social Committee, New Internationalist, IMF, etc., this land grabbing at international level, at South Africa, in America, or in other countries, when we refer this term land grabbing, it is actually not an illegal thing. It is a large scale acquisitions by the international investors. It may be private, it may be foreign body, generally having the area of land over 200 hectares. It may be often without compensation or consent. So for that purpose, we have to refer that there are various international conventions, treaties, protocols, declarations, these are generally we can refer it as a soft laws. They are generally not a binding one regarding land grabbing, because there is no such specific right to land in international law. We have the right to property, which covers the aspect of the land in broad sense. So this issue of land grabbing is less highlighted in the international law. But we should focus particularly on this aspect of land grabbing in India. As we don't have that much time that I have been allotted, I have been informed that I have 1 hour of the time. So we should skip this part of the origin and history. So let's go to the point regarding the anti-land grabbing laws in India. Law is a broad term. We have that specific act in the Gujarat, in Andhra Pradesh, in Karnataka. So that laws are the main part under which procedural aspect is under the rules framed by the specific body, by the specific state for the machinery. Earlier, Andhra Pradesh and Telangana were the part of the same domain. But in 2016, Telangana state was being separated. So at that time, it was being came to the notice that there are large cases which are pending, and for that the purpose of the law was not implemented. So here Andhra Pradesh in 1981 was the first state to enact the law, but then after in June 2016 it was again Telangana, who was actually the part of the Andhra Pradesh, become the first state to repeal it. Important thing is that when we observe the data of NCRB, it was being revealed that when we don't have the specific land grabbing law, we have to rely upon the common law. For example, under the IPC, we had the provision of section 447 regarding the trespassing. So, as per the data of the NCRB, Telangana has reported highest numbers of the cases in the next year of its repeal. So, it is always the need that there should be the specific kind of the legislation regarding prohibition of the land grabbing. So now we are dealing with the other states. For example, in the Odisha, there was one bill, but it was being dropped. Same way in the UP also, the bill was prepared, but then it was dropped. In Goa, the procedure is going on to enact the law. One-man commission headed by V.K. Jadhav, retired judge of the Bombay High Court. One commission was being constituted. It was being came into the light that there are so many cases of the land grabbing, land encroachment in the Goa. So they are now considering this aspect to enact the law. Now this is the sample of the form. Particularly this is for the Gujarat. In Gujarat we have this law. So if any person is a victim of land grabbing, at that time, as per the Gujarat Land Grabbing Prohibition Act, the procedure is being provided. So for that purpose, that applicant, that victim who is having the right over the land as per 712, or having the long tenancy, or we can say long acquisition of that property, that person, if any person is victim, if he is being dispossessed, so he can approach to the concerned collectorate, district collectorate. This is the form as per rule 3.1. This is the format under which that person has to apply to the district collectorate. He has to mention about the survey number, about the block, about the all details of that property, that land where it is being situated, what is the summary of the evidence, that proof are required to be attached. Here, when the law was enacted in 2020, it is very important to mention that it was the part, it was covering the aspect of the land only, but as per the various judgments of the Honorable High Court of Gujarat, this is now not being limited to the land only. If we could refer to the judgments, for example, in Vadodara only, there is the judgment of R.K. Patel in the 2022. It was being held that there was in Vadodara, there was one Suleimani chawl. So that chawl was illegal. So the government has taken action to demolish that chawl. So at that time, there were few persons who were residing in the chawl who become, actually they were landless. They were not having any kind of source of income. So this Mr. Patel was a very gentleman. So he has given his shop for the purpose of residence, for the purpose of livelihood, to do the business. So these persons who were having that shop, they were not actually, they don't have any kind of right over the shop. It was on the rental basis, but still what happened was, for a period of 4 years, they were not giving any rent. So at that time, that person has requested, that person, Mr. Patel, issued the notice. So they were not vacating the premises, they were not paying the rent. So at that time, the complaint was being filed to the district collectorate, and as per the directions issued by the Honorable High Court, particularly in this matter, that FIR was required to be launched against that persons who were having the rented shop also. So this issue of land grabbing is not just limited now to the specific land, but it includes anything, the structure over a permanent structure or a kacha structure over that land, which may includes any kind of building or construction. So this is the procedure that you can see. There would be one complaint. It should be along with the 2,000 rupees of the demand draft or cash, but it is the part of the form that a person has to pay this stipulated amount to the concerned district collector. Then after, one committee is constituted, so that case was being put up before that committee. So that committee would examine the aspects of the land grabbing. They will call for the records. They will examine even particularly last year also, in December 2024, the matter came before the Honorable High Court that this procedure, as per Rule 5 regarding the inquiry by the committee, is not stringently followed. So for that purpose, High Court has also issued the guidelines that in a specific stipulated period, the committee has to examine, they have to direct the police to arrest, they have to file the FIR, and the matter should be put up before the Honorable Court for the necessary trial and adjudication. That this law is providing the time limit of just 6 months to dispose of the matter. But the irony is that the Gujarat's Act was being challenged. Constitutionality was challenged before the Honorable High Court for long. So just in 2023, it was being held that the law is constitutional. But again, this judgment of the Honorable High Court was challenged before the Supreme Court. So as of now, the irony is that there are so many cases of the land grabbing pending before the court, the concerned special court, but the trial is not at all under the process. This is the constitution, as you can see in the slide, constitution of the committee for each district, in which you can refer to the members. It is the SP, it is the RSC, residential additional collector. It is, as I have mentioned, land grabbing is the part of both civil law as well as the criminal law. So the members would, as such, would gather every 15 days, and if prima facie, if it is being found that there is any kind of evidence regarding the land grabbing, they may direct to the concerned police. and the investigating officer has to consider the case fit for the FIR only, and they have to file the charge sheet. And then after the matter would be go for the trial adjudication. So generally when FIR has been launched, it is being specifically mentioned that the burden of proof is on the land grabber now, that accused person, to prove that he is having the title or ownership over that land. As I mentioned, generally there are 4 states, but among the 4, Gujarat is having the highest kind of punishment. It is minimum 10 years and maximum 14 years. As per the CRPC, now it is BNSS, the procedure for the adjudication has been provided. It may be like summons case, warrant case, trial by the sessions court, but generally when a special law has been enacted, then the procedure provided in that specific act only would be governed as per the rules subsequently so provided. Here it is the important part that special court should be established, special public prosecutor should be appointed, and the matter should be considered as a matter of priority by the court. So now, besides this committee constitution, certain states have set up the authorities. For example, economic offense wing in Gujarat for specific Ahmedabad district, or in Uttar Pradesh it is the Bhumafia task force. But the important part is that there should be some kind of resolution, government resolution, having the authority to establish such kind of authority. For example, in Tamil Nadu, there is no specific law, but they have established land grabbing cell. So when there is the lacking or absence of the law, and when they directly constituted the cell, as you can see in the slide, in 2021, they have issued the government order, GO, dated 28/7/2021. The matter was challenged way to the Supreme Court in Government of Tamil Nadu versus L. Thamaraselvam. It was being held that the constitution of the cell was illegal. So it was quashed. But when we do have the law, for example, in Gujarat, then the cells constituted by the Mehkam, it was being held that a part of the valid constitution. Now the next part is the constitutional validity. Whenever the law enacted, not only in Gujarat, but also in Karnataka or in Assam, they have been challenged before the High Court. But in all states, the validity has been considered as a legal one, as per the constitution. Regarding the amendment, it happens that sometimes when the law has been enacted, there may be some lacuna. There may be non-inclusiveness of various provisions. There may be some issues regarding the implementation. Regarding the land grabbing also, in Gujarat, if we can see the latest amendment, it was being held that there are so many forest areas in which the tribal people are residing. They are cultivating from years and years, from decades and decades. So, by the amendment in 2022, it was held that this law will not be applied by affecting the tribal rights under the Forest Rights Act 2026. Another provision regarding the appeal by the order of the special court to the High Court within the period of 30 days was also inserted in the law. So, amendments are the part and parcel of the machinery when it is being implemented. So now if you can see the comparative analysis of the land grabbing laws, various laws enacted in Gujarat, as I have mentioned, it is the collectorate to which the matter is to be filed, and there would be the special court. Special court having the single judge only. But in other states, For example, in Karnataka, the law prescribes for the chairman and 4 other members who are presiding over the special court. In Assam, it is the district and sessions judge or ADJ, while in Andhra Pradesh, it is the chairman and 4 members. So there is no one kind of uniformity in the specific laws being enacted. There are the similar law points, but they have adopted their own machineries, own procedures in order to give effect by their own territorial issues. So these are the various comparative aspects. Now, the next and important part is the use of the digital platforms. In Gujarat, if any person is willing to file any complaint regarding the land grabbing, the specific portal has been developed. It is called IORA, Integrated Online Application. So it is the portal under which a person may directly fill up the data and then it can apply to the government. In Kutch, recently only, one person having the public interest, having all the data, have filed a complaint to the collectorate. This is very interesting case. So I must emphasize on that applicant was a person having the public spirit. So in the Kutch, he has filed the complaint to the collectorate claiming that there is the encroachment over the government land having the worth of more than 200 crores. That person who has actually encroached, who has grabbed, now this person, the applicant, has gathered the data through the online any ROR application. Revenue records are being available in Gujarat through 712 are available. So through Google Images and revenue records, he has filed the complaint that this person has actually encroached and grabbed the land of the government and has constructed whole party plot. It was before few years ago was only 7,000 square meter, but the encroachment in 2025 is now extended to more than 30,000 square meter. Just imagine, it is worth of 200 crores now. So he has filed the complaint, collectorate has examined and has directed the police to register the FIR. When the law was actually implemented in 2021 and when the data was collected, it was found that in Gujarat, the land grabbing, the value of the land is more than 500 crores. But in 2025, it is estimated that the land grabbing, government property as well as private property, is more than 5,000 crores. Just imagine how much property is being grabbed by the bhoomafias or the encroachers. In UP, a person can file the complaint. As you can see in the slide, anti-bhoomafia portal has been developed by the government. So through it, a person can file the complaint. As I have in the beginning mentioned that in absence of the special laws, we are having the allied laws from law. So it is not just like the specific term of the land grabbing which is being came into existence only through the enactment of the law, but there are also other form of the land grabbing. For example, trespassing, encroachment, taking over the land, usurpation, illegal possession, eviction, nuisance, forceful dispossession, unauthorized occupation, takeover. So these are the forms of the land grabbing only. They are having the similar characteristics and overlapping in nature. So at that time, if it really happens, a person, for example, living in the Maharashtra, will not having the special law. At that time, it really happens, if trespassing is there, he can approach to the concerned police officer and that police has to file the complaint under the IPC, or now it is under the BNS. It is also imperative to mention that if the land grabbers are having the modus operandi or having done this crime similarly for more than one attempts or that kind of background, then it would be the part of the organized activity, which is under section 111 of the Bharatiya Nyaya Samhita. It is specifically being covered. So land grabbing is now a part of the organized activity also. Now, when the property is belonging to the panchayat, we all know 73rd and 74th constitutional amendment, which gives the constitutional status to the panchayat and municipalities, municipal corporations as well. So now, whenever the panchayats, all these local authorities, the property or the land belonging to the local authority is being encroached, at that time, they have that power to remove that encroachment. But this power to the panchayats or this local authority is limited to that land belonging to them only and not the private persons. So for that purpose, we have that specific land act of the panchayats under which the procedure is being provided, that the notice is to be issued, due process has to be followed. So then after, if a person is not vacating that property, at that time they have the power to take that land back. So most of, if you can see this map, in India, most of the states have enacted the panchayati law. So this is the list. The same way is for the municipalities, that they do have the power to impose the penalties. It also varies from state to state. For example, in the Goa, it is up to 100, or in the MP, it is up to 250. The important part is, in the Uttar Pradesh Municipalities Act, if any person is informing the local authority, then that informer will be rewarded for the information regarding the encroachment. So again, this is the map showing that most of the states have enacted the law relating to the municipal councils and municipality relevant to the law. The next part is regarding the municipal corporations as well. So it is also being there. The machinery is being set up. Now this is the data showing that the cases of the criminal trespass or land grabbing is not just a specific crime. There would be some kind of purpose, that in order to take that land, in order to grab that land, the wrongdoer has to manipulate the data. Sometimes it is like he will use the force, but sometimes in order to get the land, for example, if a person is NRI and having the land over that situated for long, he may take that land, he may put up that signboard that this land belongs to them. But sometimes it happens that the villager is not having the knowledge about the dastavage or that sale deed, and the person is manipulating the data. So it is generally a crime relating to the documents and the property. So if you could see the data, the cases of the criminal trespass from 2019 to 2022, it is increasing day by day. Numbers and the percentage of the crime rate, it is increasing not just in the trespass, but also in the documents and the properties as well. So we do have this machinery as per the BNS. The provisions will be attracted as per the BNSS, BSA. The procedure provided will be applicable before the court for the inquiry, for the trial, as per the Civil Procedure Code 1908. It is a civil wrong, so the competent civil court shall have the right to try that matter. But besides it, there are the other laws as well. For example, Specific Relief Act 1963. So if a person has been dispossessed, there is provision section 5, section 6, under which generally within the period of 6 months, a person has to approach to recover the possession of the land. If a person is dispossessed, then under this law, it is a matter of civil issue. Then as per the Specific Relief Act, the procedure under the CPC will be applicable and the matter can be filed before the competent civil court in order to get the property back when it is being dispossessed. there are certain other laws, for example, PASA. It is the Anti-Social Activity Prevention Act that generally most of the states have enacted this law. So when there is the habitual offenders who are committing the crime, so at that time, the collector shall have the power. It is the authorized, it is the competent authority that under the PASA, the matter can be filed and that person would be put behind the bars. Here, I would like to draw your kind attention towards one judgment of Justice Paresh Upadhyay of the Gujarat High Court, that generally when we have in Gujarat, for example, there is the specific legislation called Gujarat Land Grabbing Prohibition Act. So at that time, the police cannot directly do the process under the Land Grabbing Prohibition Act in light of that habitual offender has been committing the offense under the PASA and putting behind the bar. Again, the specific wording by the Justice Paresh Upadhyay is very relevant here, that under the PASA, the word is the property grabber. Property grabber is actually one of the form of the land grabber only. So the court has held that the due process under the land grabbing law is to be followed in order to consider the case fit for the FIR for a criminal matter. And court has mentioned that there is the difference between law and order and public order. So more or less, the land grabbing is an issue is not just limited to the one law. There is the law concerning the eviction of the unauthorized occupants from the public premises. There is the law called PESA, Panchayat Extension to the Scheduled Areas Act 1996. There are the law called Wildlife Protection Act 1972. For the forest property, if any kind of encroachment, then the range forest officer, assistant conservator of the forest, who is having the right to take the action for the protection of the forest property, which is actually I'm the part of the body. So they are also filing the complaint. They are having that the specific autonomous body under which the action for the land grabbing in case of the forest area for the land belonging to it, the action may be taken. Prevention of the Money Laundering Act may be also applicable when land grabbing involves money laundering. In Andhra Pradesh, there is the law called Andhra Pradesh Land Encroachment Act. In Bihar, there is Bihar Land Dispute Resolution Act and other laws. So, there are various legislations which are actually apply in case of land grabbing. Regarding the adverse possession, this is one of the very important part of the land grabbing, that the person may have the right over the possession or to claim the ownership, but it is not in black and white that a person can claim, particularly when there is hostility. There are certain judgments of the Honorable Supreme Court that the title, that the status of the land grabber would be always the trespasser. He is not, he would not be automatically being granted the title of the adverse possession when there is unauthorized occupation. There was also the demand that this concept of the adverse possession should be abolished. But in 2023, Law Commission in its report has specifically denied that this possession would be, this concept of the adverse possession would be there. So the court is considering the status of the land grabber as a squatter only. In Gujarat, there are also other laws like Gujarat Police Act, under which the police will be having the right to arrest and take necessary action for the obstruction, the Mamlatdar having the right over the taluka in its territory under the Mamlatdar's Court Act, the collector having the Gujarat Land Revenue Code. It is a very important civil law, revenue law, which is giving the right to the collector to remove the unauthorized occupation, encroachment. There is also the law called PASA as well as Gujkotok, Gujarat Control of the Terrorism and Organized Crime, that land grabbing under this law is an organized crime. So the police as well as the special authority is having the right to consider the issue as a large scale one, considering it as a burning issue. Now regarding the regularization, that sometimes it happens that a person has the property, for example, a person having that illegal occupation, but he has claimed before the revenue authorities to regularize it. Generally, this kind of regularization is permitted in exceptional cases only, as it was held in case of Jakpal Singh, because many times it happens that using the muscle power, money power, a property is being grabbed. Even sometimes the Gram Sabha, Panchayat or the local authority may not have kind of knowledge over the property. So a person is having that possession and he is claiming for the regularization. So it is not permitted. So in this case, the Supreme Court has held that one specific rules are required to be enacted for the purpose of prevention of the regularization. Now, the next part is the general position of the land grabbing in Gujarat. So, as a researcher, when I studied, I have filed the RTI application under the Right to Information Act 2005. I came to know that under this law, the government has also right to take the suo moto action. But the applications which are filed by the government, whether it is by the revenue authority, by the departments, the applications are very low in number compared to the application filed by the private individual. So in 2020, when this law has been enacted, after that, there is a large scale awareness of the people regarding the private lands. And when we look at the value of the land, the area of the affected land, it is a very high and it is in the crores. When the application has been filed, it was also found that many applications are frivolous, they are vexatious, a person may not have that documentary evidence to justify the claim. So the application may be given, but when it is being scrutinized, it was found that the matter may not be fit for considering it to register an FIR. Even if the FIR may be registered, then after when we look at the data, the cases in which the charge sheets are being filed, the cases are very low. So in all, we can say that this is a very boon. It is like important legislation under which a person is getting the right to file the complaint, but the effectiveness of the land grabbing laws is still in question. It is actually varies from state to state, but at least we are having that machinery under which the victim can be benefited to file the complaint. So in all, there is the existence of the special law, or in case if it is not, then the allied laws is at least safeguarding the rights of the individuals. So can we say that this law, for example, in Gujarat, is served as panacea against the land grabber? No. It is like partially there is some kind of the existence of the law having the deterrent effect of the minimum 10 years punishment up to 14 years. There is the hefty fines. There is the committee which is working properly, but there are certain challenges in the implementation. Land grabbing is not just a civil or criminal issue in the law, but also there are certain environmental facets such as green grabbing, deforestation, having the effect in the climate or in the ecology. So now the last question that arises is when we have the general laws as well as the special laws, what would be the applicable law in case of land grabbing? So there is one Latin maxim which is called generalia speciali bus non derogat. It means that whenever the specific law has been enacted, then the new cases will be filed under that law only. There is one important judgment of the Honorable Gujarat High Court. It is in this year only, 2025 only, that it is by the Justice Niral Mehta. It says that there cannot be the joint trial in case of the FIR registered under the IPC as well as the FIR registered under the Land Grabbing Prohibition Act. So, if any matter, if the law has been enacted, then it would, the law, as per the new law, as per the special law, the matter would be tried. But the pending cases, if it is not being transferred to the special court, then it would be tried under the common law or the general law only. So, in all, we can say that there is this kind of machinery, but the center can also adopt the model regarding the Land Grabbing Prohibition Act, similar to the Land Leasing Act. As we are running behind the time, I think we should now go for any kind of questions which is being there. There are so many things which should be covered, but I think it is the high time that, as I have been informed by Dr. Kalpesh Lalit Kumar Gupta sir, that we are having a lot of the enthusiastic viewers or the spectators or the concerned persons who are having the questions. So I must say this is a practical law which is having the prime effectiveness or the issues in the implementation. So, with the permission of Dr. Kalpesh Gupta sir, I now request to go ahead and in case if there is some question, I may be allowed to answer.
Yes, thank you very much, Dr. Ravi, for your great session. I can see there's a request of one more session. So sorry, it's not possible. Let me tell you, day before yesterday, I called him immediately. He was on the way on 5th June, and big celebration was there by being an Environment Day. So on the way, I told him, requested him, please take a session. So he was ready for yesterday also, but I told him Saturday being at home, so he'll be at ease to take a session. So participant, you can raise your hand uh, and then ask a question, or you can put them in the chat box. Let me. Sorry, not possible. Second season, so
Hey,
already.
if I can see the chat, there are certain
May
questions.
I ask a question, please?
Yes, yes, yes. I think couple of you already answered in your sessions already, like you related to
Yes.
tenant and then Andhra and Telangana part. Yes, Mahendra Ralhan.
Yeah. So the question is, generally, basically your experience, how much time it takes to get the land restored to the original position, be it in Gujarat, be it in any other law, how much time it
Sir,
takes?
sir, can you please repeat? I am having the issues in the audio. How?
How much time it takes for
Hello?
case to
Yeah,
resolve?
right, right.
How much time will it
It
going
takes
to
to
take?
yeah, to resolution of particular case, grabbing case.
What I observe regarding the question is that in specifically in a land grabbing case, for example, in Gujarat, when do have the law, it prescribes that time limit of 6 months before the special court to complete the whole proceedings. This is the theoretical part. But when we, in general, when we go to the court, first of all, the complaint to the collectorate is to be filed, then the FIR will be filed, charge sheet will be filed, and then at last the matter would be tried before the special court. This is the first part. If it is the criminal complaint, it would be before the police officer. Now then, in a civil case, it is before the competent civil court. So civil court takes time around 2 to 3 years by first by plaint, then WS, then the whole procedure of the civil law is to be followed. But in a special law, like in Gujarat, the in theory, the procedure is prescribing the time limit to complete the trial before the special court is 6 months. But as per my understanding, there are, I think, very less cases which are being tried and in which there may be the order of the bail, but the whole trial completion is very minimal that I have been observed.
And we can go fairly with the criminal proceedings also.
Criminal, actually, sir, this law is a special law. So, as per this law, it is like the special court is having the powers of the criminal as well as civil law. For example, if a complaint has been filed and the collectorate has directed the police to register an FIR, at that time the special court can return the land as well as punish the wrongdoer.
Okay.
Both the things would be under the special court only.
Okay. Nee, I mean to say, like in Gujarat, Maharashtra, they know such anti-land grabbing act and all. So
Yes,
then
sir.
you need to follow the light laws, that is trespassing acts or whatever you say under the IPC or BS, this new BNS and all.
Yes, sir.
So that is one provision. Otherwise, under the Maharashtra Land Revenue Code, you need to go
Correct,
there.
sir.
Okay.
It is the civil part,
Yeah.
revenue part.
So you need to go fairly both in these cases, no? In case of Maharashtra,
Yes, sir.
because there is no special act for this.
Yes, sir.
Okay.
If, as I have mentioned, there are the various forms of the land grabbing. So at that time, a person may approach the different authorities to get the possession of the land, or if that victim desires for the speedy expeditious trial, he may also approach to the court.
Thanks so much.
Okay, any other questions, query participant?
I can see one question in the
From
beginning,
Surat.
that Andhra Pradesh Land Grabbing Act will applicable to the Telangana. Actually, it was applicable, but Telangana government has repealed it. So before the separation, it was being applicable. Then, sir, does land grabbing include tenant not vacating rented house and also not paying rent using intimidation? Yes, sir. As per in Gujarat particularly, when we have the special law, there is the judgment of Honorable High Court that this law would be applicable to the rented house and the rented shops. So at that time, the law would be applicable. Then, sir, how much effective this means of the anti-land grabbing tools are like in practical world? Do people actually follow these laws? Cause one is land grabber is an influential person in most of the cases. What I believe, when we consider in a practical world, I believe at least we are having the law, so there are the chances that the matter may be settled. You may get the land back if at least you are filing the complaint. So there would be the effect of the having the money. So the act is duty by for the procedure. We are in the authority like court, high court or the Supreme Court, to which you can go in case a person is influential. So at least we are having the good thing that the existence of the law. Can you kindly share the name citation of the judgment? I am not getting the exact name, but I will share in detail to the Dr. Gupta sir. Additional session, it is by the Gupta sir only. I know that the time has been leaking. So in Surat, we have seen few land grabbing files. People were arrested. However, they are out on bail and counting the unauthorized possession. Who can restore the possession in Gujarat? In case if it is being there, a person is bail and is continuing to do this kind of unauthorized activity, then according to me, you should directly approach to the High Court. Then there is definitely the chances. Generally, just before 1 day ago, there is High Court can provide a remedy instantly. Or if land grabbing can be considered under the land dispute, so is it suitable for making land dispute act in future by higher authorities like Supreme Court? Sir, land grabbing is one thing, land dispute is another thing. So for the land dispute, we have the revenue laws. For example, under the revenue laws, land ceiling act, then revenue laws. So it would be not justified to say that all the land disputes are the part of the land grabbing. So in case if there is the issue of the title or the concern holding, so it would be justified to say that the point under it is not one of the direct part of the land grabbing. Did you ever come across issue where illegally grabbed land which before restoration and resolution of the litigation had gone waste, which disabled the landowner to make effective use of such land? What remedies can be expected here? So here, when there is the illegal land grabbing, but when first of all the problem is that if the complaint has been filed under this the special law, so at that time if the settlement has been happen, so it is the best interest that everything is documented. So restoration, if there is some kind of proof, then after only the land would be handed over. So if there is the resolution by the authority, by the court, so then we are having the proper proof over it. So here, if it is always said that the buyer beware, and second thing is that ignorance of law is not an excuse. So when we have that kind of the transfer of the property, then it is always in the best interest that it is always being documented. Then can you share the citation of the High Court that passed by Justice Upadhyay, Justice Nirmal Mehta? I think I will definitely share, but you can also Google on the bar and bench also, which is being reported. Rental property can file. Yes, it can be filed. It is by the judgment of the High Court only. Then can we take the remedy from the civil and criminal court simultaneously under the land grabbing? Yes, it can be done. So civil court for compensation, criminal court for punishment. It is under the case of the trespassing. That is the open. Okay, I think this is a very broad issue which is covering many
definitely.
aspects. I am trying to justify. I am also, we all are the law students only when these kind of issues are being discussed. So I tried my level best to justify, to discuss, and also to give my inputs. So thank you very much, all of you. It was really nice interactive session. In fact.
Yeah. Thank you very much, Dr. Ravi, for your insightful session, I would say. And we can see from, chat box very messages for the complimenting for your sessions on, and then especially content and your experience in PhD work. Again, this law, you can say it's evolving. A lot of things are, will come in your future. But again, we should have some idea like what's going on right now in Land Grabbing Act. So we can learn, impart in classroom or use in that practical world as a profession. So on behalf of organizing committee, we are grateful for you, Dr. Ravi, for your wonderful session, and look forward to seeing future programs also. Thank you very much. Thank you.
Thank you very much, Team Sambhav, Team Pro Bono. Thank you very much for the opportunity, sir.
Thank you.